Every day, we're hit with endless user agreements that we mindlessly click on, accept. Well, in tonight's Law and Disorder, it's a warning to always read the fine print. A man is suing Disney after his wife died from an allergic reaction after eating at a restaurant on Walt Disney property. But Disney is trying to dismiss the wrongful death lawsuit because the man had signed up for a Disney Plus app free trial years earlier. And in the fine print of that agreement, it said that he agreed to settle any lawsuits against Disney out of court. Well, joining me now to discuss this is law professor Daniel Karon. So, Professor, nice to have you here tonight.
It's good to be here. Thank you.
Disney is saying that the terms and conditions of the contract that the man signed when applying for that Disney Plus app should also cover the death of his wife on Disney property. That seems a bit of a broad stretch. Do you think that Disney has a legal foot to stand on here?
There's a doctrine in the law called remoteness, which kind of means a bridge too far. Yes, he signed an app with terms and conditions that precluded him from suing anything Disney related, any claims arising under his involvement with Disney, which you could argue, they're arguing, involves going to the theme park. But goodness, that is really, really a stretch. It's not any different than my Amazon Plus subscription precluding me from suing Amazon when a driver going to somebody else's house hits me with a truck. It's ridiculous. It's not fair. Will it hold up? It might, because arbitration law is stacked against victims these days. And that's really, really sad.
So let me ask you about that. That is the specific term that Disney is pushing for. It says that all disputes will be resolved by arbitration. Why would they want an arbiter rather than a jury to decide this case?
Because arbitration is really, really unfair to consumers. The data showed that about 97% of cases in arbitration resolve in favor of the company or the defendant. Why? Because the defendant picks the arbitrator, and the arbitrator is not going to come back for another job if that is he or she doesn't rule for the company who hired him. So you're going to see almost all the time companies ruling in favor of arbitrators ruling in favor of the companies who hired them, and those definitely are not consumers. And that's precisely why arbitration is so anti-consumer and so totally unfair.
You know, and also in a case like this, a wrongful death case, there's a lot of emotion involved. Would a jury be more apt to be sympathetic in that way?
Juries care about victims. They cry, they're affected. You make pleas to jurors. Arbitrators don't care. They're cold and hardened, and they've seen this a million times before, especially if they're hired by Disney. An emotional plea in an arbitrator is going to absolutely fall flat, get the plaintiff nowhere, and that's another reason, in keeping with what I remarked on a second ago, why Disney wants this case going to arbitration and not to a jury, which is in keeping with folks' Sixth Amendment right to jury trials. They want to strip victims of that right in favor of arbitration where the deck is stacked.
You know, Disney is also arguing that they're not liable because it's the restaurant's fault, right? Apparently the restaurant is on the land that Disney World owns, but Disney doesn't actually own that restaurant. With about 30 seconds left, is that a good defense for Disney to argue?
I don't think so. There's a perfectly good legal hook to bring in Disney for what happened at the restaurant. Disney's website advertised the restaurant as serving allergen-free food. It didn't. Someone died. Disney has responsibility for what happened along with the restaurant, not separate from the restaurant. The restaurant isn't left on its own. Rather, they ought to be sued together. They both bear responsibility for what happened.
Professor Karon, thank you so much for your expertise.